Welcome to our second communication session of the day. Today we are talking about DD boards and public communication in the digital age, and we have two partners from Bricker Graydon here that are going to talk about the legal PR aspects that you need to know as county board employees. And I want to thank them very much for being here today. We have Beverly Meyer and Becky Princehorn here. All right, thank you very much. And they have a lot to cover, so we are just going to get started.
Yes, we'll start by saying, don't get intimidated by the number of slides that you see. So how's that? I'm Beverly Meyer. I am a partner with Bricker Graydon, and I'm a public sector lawyer. I work throughout the public sector. I do a lot of general representation of boards, whether they be DD boards or school boards or municipalities and townships. And my go-juice is labor and employment. So within that realm, I'm joined today by my colleague, Becky Princehorn, who is going to be addressing some of the issues in the second part of our program today. Becky practices with Bricker Graydon out of the Columbus office and is a public sector lawyer and spends a lot of time doing all things public finance. So with that, since we have so many slides, we'll be off and running. We're here today to talk about communications in the digital age, and what we're really going to be focusing on is what's changing in the law in that regard, because let me tell you, there's a lot. So before we get started though, oh no, this is supposed to work. It's on. The clicker. Can you make it work? It's okay. We'll just use the advancing slides. Here comes our technology person. Slight apologies. There we are. Is it good now?
Yes.
Okay, great. First, the fine print, because we are lawyers after all. And these are just things I want to make sure that, everybody's aware of. Number one is, although we are lawyers, we are not giving you legal advice because we are not allowed to do that when we do these presentations. Number two, please feel free to ask questions though, because it seems like we all have the same questions at the same time, and it's great to learn together. Please center your questions and hypotheticals in general application, because if you do have specific factual questions, we want you to be turning to your legal counsel to get answers for those questions. And thirdly, because this is a very rapidly evolving area of the law, as you'll see in the cases that we're going to be working through, please make sure that you're independently verifying whatever citations and the things that you see in this with your legal counsel, instead of just adopting them as the latest, greatest whenever the time arises. And it's not working again. There, we'll just do it this way. So today, the introduction to today's agenda, and this is my aspirational agenda because we have a lot of slides. The first is we're going to talk about digital technologies such as social media and email and what to do on the internet, okay? These are powerful tools at your disposal. It's on an automatic thing, interesting. Powerful tools at your disposal, and we want to be using these tools rather than being used by these tools. The second thing that I'm going to talk about is creating a public forum, which is what you are doing every time that you are reaching out through social media or Twitter or Instagram or creating a website. So we want to make sure that you understand what the law expects of you and what your abilities are to regulate whatever you're putting out there. Thirdly, in that regard, we're going to talk about the new legal pitfalls that we have as a result of some of the recent cases, including two cases that were handed down by the United States Supreme Court in March of 2024. Then we're going to touch on just a little bit of the interest of the students and parents and your DD boards as it relates to privacy, because anytime we are dealing with the internet, we are also concerned about privacy interests, right? And finally, Becky's going to talk with you about DD ballot issues and the movement that we're seeing from the Auditor States guidance and things to be careful about whenever you're out there advertising and discussing your levy. Okay, so firstly, the First Amendment. It's why we're all here, right? I mean, maybe not you, but it's why I'm here today. And I'm a little bit of a constitutional law geek, so I apologize in advance. But I wanted to make sure that you had the text in front of you and why this is such an important issue for you as a public entity. This is what it is. In a nutshell, that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech. That's the important part for us here today, or of the press or the right of the people to peaceably assemble and to petition the government for redress of grievances. This is a public-facing law. It does not apply to private organizations the way that it applies to you as a governmental entity. Okay, and so that's why whenever we're about these restrictions, we need to be very aware as to what the rules of the game are, because you are bound by this, and because you're bound by this, you are able to violate it unintentionally, and that could result in potential liability for you. Your public has the ability to bring claims that are constitutionally oriented using a number of different statutory vehicles to do that. And they can get very expensive very quickly because all of them involve the recovery of attorney's fees, even if there's no economic damage. So that's our starting point. So what do we need to be aware of? Well, the first thing we need to be aware of is that the First Amendment deals with what happens in a public forum. And you're like, what's a public forum? Well, it's a fancy legal phrase that the courts are going to use in all the cases that establishes where the speech is occurring. That's a public forum, where the speech is occurring. And there are 4 kinds that have been recognized in the law, and you see them listed here. So anytime you, as a DD board or an organization, public organization, are participating on social media or establishing a website or even having a meeting with public participation, you are creating a public forum. And the type of forum that you create determines how much control you can assert over that forum. So let's dig into that just a little bit. The first type of forum is called a traditional public forum. This is what I call open public. It's things like the town square or general sidewalks and roadways, standing on a street corner, you know, talking, petitioning, all of those open spaces. Interestingly enough, we don't have the cases yet to fully articulate how social media fits into this. So the Supreme Court has been wrestling with this question, like, where does it fall? What do we do with social media and what kind of form does that become? And I wanted to put this case in front of you as the Packingham versus North Carolina case where 2017, and we've had a lot of movements since 2017, I'll tell you, that's 7 years already. They stopped short of calling social media the traditional public square where people turn to get their news and to, you know, protest and articulate their thoughts. They stopped short, but we're pretty close to that. Okay, so just understand that when you are on social media, it's the same as if you're standing out there in the open and inviting people to comment. Designated public forums is the second type. It's very close to a traditional public forum, but it's a more confined space, sidewalks, for example. But those two we're going to set aside for today because the next two are what we're really going to get into. This is mostly where you are going to be living if you are out there communicating on behalf of your organization on social media or through a website or throwing things out into, you know, the atmosphere, so to speak, the internet. A limited public forum. So a governmental entity such as you can create a limited public forum anytime you open a platform up for people, okay? And if that platform is limited to certain groups, meaning people who are visiting your website or people who are subscribing to your feed or have, you know, pinned you for something, that means that you are inviting them in And when you invite them in to that limited public forum, you have to comply with certain rules. So one of the examples of this is a case that comes out of Milford Central Club, Good News Club versus Milford Central Club. It's a United States Supreme Court case back from 2001. And it talks about how a school district had created a limited public forum by allowing people to come in and have meetings there. Now, the school district probably wasn't thinking that, oh, we're going to go out and create this public forum, so we're going to have to abide by these rules because we're doing this. But, you know, this is just one example of unintentionally how these things can happen. Non-public forum is the other area that you're probably going to end up in frequently whenever you're out there participating in social media and communicating using the digital tools at your disposal. A non-public forum refers to government-owned property or space. Okay, so that would be, again, your websites, your social media feeds, that has neither been traditionally open to the public, right? So it's not something that somebody can just like walk into freely. They, you know, they have to have some kind of reason to be there or invitation to be there. And even if it's been open for limited purposes. So in a school setting, because it's an easy way to kind of get our heads around it, think about, you know, classrooms or the school library, other areas where we're inviting people in. In your social media setting, think about your website. How many of you have websites, right? Yeah, pretty much everybody. It's how we communicate information. It's how we let people know the services that we can offer. Well, the courts are already tracking onto that. Already back in 2000, in the year 2000, the Sixth Circuit Court of Appeals, which is the federal circuit that governs our geographic area here in Ohio, said that if you had created a website, a city here had created a website, and the court said because the city created that website, it created a public forum, but this court, the Sixth Circuit, designated it as a non-public forum because the city hadn't allowed comments to be made, right? So it was a one-way communication. So that gives you protections if you are the entity that is pushing information out there. If you're not allowing people to comment and push information back to you, it gives you greater controls and more constitutional protections. So my helpful hint, turn off the comment section, because if you have it on and then someone starts saying something that you don't like what they're saying, and then you try to turn it off, that's when we get into trouble. Okay. So you have the ability to regulate your public forum when you create it, when you have a website, when you push stuff out onto social media, when you have an Instagram page on behalf of your organization. The general rules of thumb are that you cannot restrict the content of what people push back to you. So whenever you push something out, that's an invitation for them to push something back to you, right? You cannot regulate that content, but you can under certain circumstances, because we have kinds of speech that don't have the same protections as other kinds of speech, right? And the kinds of speech that don't have a lot of protection are these that you see listed here: obscenity, defamation, things that aren't true, because untrue speech is never protected, okay? Never protected. Fraudulent speech, incitements, which means things that are inciting other people to take action that's, you know, unlawful. Fighting words, and you'll see my 2 stars there because that's really difficult to define in this day and age, right? I mean, one person's fighting words is another person's, you know, joy. And then speech is integral to criminal conduct. So if you're encouraging somebody to engage in criminal conduct, so you can establish these rules and you can pretty much regulate these kinds of speech outright if you have a policy, but understand that it's not universal. It's not waterproof, because we cannot regulate content outside of what you saw on this slide. We cannot regulate content. Whenever we create a public forum, all we can do is put into place reasonable time, place, and manner restrictions. So what is content? Meaning we can't regulate the content. It means the message. We are not allowed to push something out into the stratosphere, invite something to come back, and then turn it off whenever we don't like what it says. That's the content, right? So if we get criticism back in response to what we sent out, and we've created a very large public forum, we're kind of stuck with it. I mean, unless you really don't care about the legal liability, and then you're just like, well, we're just going to block them and turn it off, and then we'll deal with the lawsuit that we get, because you will. So that's just something to be thinking about and keeping in mind. So when we talk about, content, the message, we have a hard time restricting that and regulating that. I want you to know that there are different rules for the different types of forums. So that's why I went through, I know it's like, there's a lot here. So depending on the type of forum that you create, there is a different level of scrutiny that is going to apply to what you do with that speech that comes back to you, okay? If you go out there and you create what we call the traditional public forum, which is treating your social media and your communications as if you were standing in the middle of the town square and proclaiming it to the world, you have very, very little ability to do anything about what someone responds to you. Okay? So we are going to do everything we can to avoid creating a traditional or designated public forum. Because if we try to regulate what happens in that forum that we've created, and we receive that lawsuit, the courts are going to look at us under what's called strict scrutiny. And that strict scrutiny standard that they're going to apply to us and to our conduct is going to say, was our action, was it to further a compelling governmental interest, which I'll tell you, compelling is really hard to reach in the court's eyes, and was our action narrowly tailored to achieve that interest? So are we regulating this because our interest is so important and we're doing it in the narrowest way possible? That's strict scrutiny. There are very few actions that survive strict scrutiny. So to avoid being in that situation, we don't want to create a traditional or designated public forum, okay? How do we do that? We limit the people we invite things to, and if we have a website, we don't turn on the comment section. We are not inviting speech back. When we get to the limited public forum, which is where most of your stuff is going to fall, right? So a limited public forum, if you have a social media page, if you're participating with Instagram, you're creating a limited public forum. The pressure test for this is what you're doing in response to the speech you get back. Your interest has to be significant, but it doesn't have to be compelling, okay? So it's a lesser standard. When we talk about the pressure test, the courts are in a hard manner, but not so hard as if you had stood on, the public square and invited the speech back. So if it can be determined that your action was reasonable and in furtherance of a significant or important interest, then the chances of your action standing are much, much better. And then the non-public forum, which is that city website case that we talked about where they didn't allow any comments and the court said, that's a non-public forum. You have a lot of ability to regulate what happens there. You're going to get a lot of deference from the courts if anyone ever, calls you to task for whatever you're doing in that regard. Okay. Have I thoroughly confused everybody at this point? Yes. Yes.
Honestly, just
So we're trying to see, he asked as a comment restriction just specific to the website. The cases that we have so far are to the website. Now, what we try to do, us lawyer geeks, we try to take those standards and apply them in a lot of different situations. So I would make that same argument that if you had like a Facebook page, for example, and you didn't allow comments on there, that would be the same thing. That you would then be in non-public forum land and you would have that would be okay. You'd have the ability to regulate that forum and that social media. I will tell you, I represent a lot of public agencies who love their Facebook pages and they love putting things onto their YouTube channels. And, for good reason, because we're here to serve people. We want to be in communication with them. We want them to know what we do, and we want to know what they need. And so we open those channels of communication up, right? But just understand that when we do that, when we invite people to come into our digital space, that a lot of times we have to live with whatever they choose to tell us. Because if we were to block them, or to delete their comments, or to remove what they have put under our space, we may be violating their First Amendment rights to participate in the forum that we've created. And that's what these cases are all about. Yes.
Basketball game that was coming up, and we had these comments that were, oh, watch this live stream here. I mean, they were not affiliated with our group. It was clear that they were fraudulent. So I hid them. I just hid their comments because I didn't want any of our individuals that we support to click on that and go somewhere they shouldn't. So since it was, in my opinion, fraudulent, is that okay?
Well, speaking hypothetically, if it was fraudulent, then you would have some protections in that regard. We would want you to have a policy that, in place that says, we are going to participate in social media. We're going to put this out there and understand that, we reserve the right to remove anything that is defamatory or obscene or fraudulent. We'll talk about policies. We want to make sure we have those policies in place so that we can then implement the policy that we have in place, instead of having something happen and then doing something and then implementing a policy and making it look like we're reacting in violation of someone's First Amendment right. Yes, Beck.
We definitely have to use the microphone because I'm hearing from the people on the Zoom that they cannot hear your questions.
I just wanted to say that we have a policy, but we had a similar situation with an event we were having where it was very clearly fraudulent. People were asking for vendors, and I'm assuming they were going to charge them money for a vendor space, and we were not charging people to set up. So yeah, all those people got blocked and banned. But the last thing we wanted was somebody to show up to our event and be like, but I paid $100 for this space. So just something to watch out for if you have events. That seems to be happening a lot to us.
I think it's happening, in society writ large, right? There's always someone trying to take advantage of somebody else, unfortunately. And so it puts us in the position where we're trying to proactively police that. But understand that what I've heard you both reacting to and describing is a content-based distinction that you're making, right? Which, when we're doing something on a content-based distinction, meaning because of the substance of their messaging, we need to be super careful, because that's discriminatory, whether it's a discriminatory viewpoint or a discriminatory act in violation of someone's First Amendment rights. What we can do is we can implement reasonable time, place, and manner restrictions that are content neutral. And that's our safe harbor. That's our safe space. So if you had a rule, for example, that said only organizations directly affiliated with this event are able to post comments, that might be one way of handling that. Because then we don't care what you're saying. The question is, are you related to this particular thing? This is a great example of that. This case comes to us out of my neck of the woods down in Southwest Ohio. It's Eisen versus Madison Local School District Board of Education. I don't know if you've heard of this case, but it has a long history. And it's the result of tragically, they had a school shooting. And so there was then a lot of conversation about what do we as a school district do in response to that particular circumstance. And the community was vehemently divided. Okay, do we arm teachers and staff, or do we not? What's the best way to create that safe space? The school district, they have public participation at their board meetings. Not statutorily required to, but they love to hear from their public, right? They want to know what the people have to say. So they have public participation. Their public participation got a little out of hand because people were passionate about the positions they were taking. So, they didn't allow people to speak in public participation because of how they were saying it, but also arguably, allegedly, because of what the people were saying. So they said, no, you can't talk in public participation. They got sued. Okay, nobody ever intends to get sued. They got sued. They up and down through the courts. Sixth Circuit finally said that their public participation policy, which prohibited the way certain things were presented, was discriminatory, that it constituted an impermissible viewpoint discrimination based on the content of what was being said. But the court upheld what it called a reasonable pre-registration requirement. So the pre-registration requirement was you have to register to participate in public participation like way before the meeting, and you have to be a resident, and you have to show us your driver's license if you're going to be registering, because we need to know that you're a resident. And the court said, that's okay, because you have a significant governmental interest in controlling your meetings and controlling how the school business is conducted. And so that's okay. A little more information about that. The public participation policy, the restrictions said you couldn't be in your comments abusive. You couldn't make personally directed comments. You couldn't be antagonistic. The court said, nah, that gets too close to regulating the content of what someone's going to say. Okay. Pre-registration requirement was upheld because there was a significant interest in the orderly conduct of the meeting, and people could still do other things to communicate with the board members, even if they weren't residents. You didn't have to be a resident to send an email, right? You didn't have to be a resident to pick up the phone and call a board member. So those were the alternative means of communication. So content, hard to regulate. The way speech is delivered, as long as it's reasonable and it deals with the time, place, and manner of the speech, you're going to have more latitude. Here's another example. Davis versus Coleraine Township. Another case from the Southern District of Ohio. We are really free speechers down in Southwest Ohio, let me tell you. We do a lot of these cases down there. So this involved a township that had a Facebook page. Okay. And it had a very vocal resident who got up and talked in meetings and then put stuff on the Facebook page. And one of the things they put on the Facebook page was a video that the township then took down. Now, they allowed people to put all kinds of stuff on their Facebook page when they took this one down because it was critical of the township. Interestingly, the court said deleting that didn't violate the First Amendment. And the reason that the court said it didn't violate the residents' First Amendment rights was because it was a reasonable time, place, and manner restriction. The township had argued, we don't want people to put all this stuff on our page that then, you get the spinning wheel of death and you churn and you churn and you churn. I call it the spinning wheel of death. Where you're sitting and waiting to be able to do the next thing on your Facebook page or your website. That was the argument the township made. We don't want all that stuff on there. And that's why we took the video down, and the court said, okay, we'll buy that one. It wasn't about the content of the video. And I have some more information here for you. Our slides are available. So just, more facts. Here's another one. This is coming to us from the United States Supreme Court. And this one is about threats. So I wanted to be sure to put this case in front of you so you can see how this policy expands and contracts based on the facts that we have in front of us. In this particular case, we have Mr. Ellenis, and this was the first time that the Supreme Court heard a case where they were trying to figure out what's a threat on social media and what's the constitutional protection of a threat. So Mr. Ellenis, he was arrested in 2010, charged with 5 counts of statutory violations. He was in a bad place. His wife and family had left him. He didn't have a job. He was frustrated. He's an aspiring rapper. He's putting stuff on his Facebook page that is arguably artistic expression. That was his argument, artistic expression. And then he got called out for it. And in the comment section, then he put down again, he said, this is not a threat. This is artistic expression, right? At trial, because he was criminally charged for making threats on a Facebook page, he was convicted on 4 out of 5 counts and sentenced to 44 months in prison. That's a long time for a threat on a Facebook page, right? I mean, I think so. So of course he appealed it. Third Circuit Court of Appeals affirmed his conviction. It went all the way to the United States Supreme Court and they reversed it by an 8-1 decision. Our friend Justice Thomas was the one who was like, nah, I'd uphold the convictions. Everybody else said, no, we need to look at the intent of the speaker. And I put this case in front of you, not just to show there is a lot of latitude about how we're interpreting fighting words and threats and fraudulent statements when we're talking about the internet, but that we have a court that is fiercely protective of First Amendment rights. Okay, so this was a 2015 case, right? Here's another one, Fourth Circuit 2013. This is an employment case. This was the first time where we figured out what does the thumbs up mean on Facebook, literally. And just as an aside, in the employment context, First Amendment rights operate differently. We're not talking about, that standard here today. And if you have an employee who's out there doing stuff on social media, you're going to want to be very careful on how you deal with it because it's this combination of they have First Amendment rights, you have an ability to conduct your business, and we're trying to balance those two. So totally different set of standards. But I put it up here because a thumbs up is speech. It's protected speech. So just to show you again, how are the courts wrestling with these things and what kinds of issues are they creating with you or for you as you're out there participating in the digital age. Another case, Second Circuit, 2019, Knight First Amendment Institute at Columbia University in New York City versus Trump, Donald Trump. This dealt with his blocking people when he was a presidential candidate, blocking people from his Twitter page, his Twitter feed who were critical of him. It drew a First Amendment violation, right? And the court said, and he said, no, this is a private account. This is my private account, and I can do what I want to with it when it's a private account. And the Second Circuit said, no, you are a presidential candidate. You are choosing to participate in this platform. You are creating a public forum. And when you create that public forum and you've opened it up to people, you're inviting speech back, then you must bear the consequences of it, which means that you can't just indiscriminately block people because you don't like what they're saying. So that's our Second Circuit. It all brings us to this. This is the Lentke versus Freed case. There were 2 cases that the Supreme Court took up at the same time. They decided them in March. We're going to talk about both of them here real quickly. It's important, these 2 cases, because it is the latest, greatest statement about what are the rules for social media in general, and our speech as public employees and public officials on social media. So this first case, unanimous Supreme Court decision. We don't get many of those right now, right? I mean, not many at all, which says to me, when we have a 9-0 decision on a First Amendment case, we have a case where the court is really, really pro First Amendment. And they show it in these 2 cases here. I mean, this is a court that is going to protect people's right to speech. So James Freed, city manager of Port Huron, Michigan, 2014. He was appointed to his position. He has a Facebook page. After he becomes a city manager, he gets lots of followers, right? Because that's what happens when you're out there in the public sphere. And then he converts it to a public official Facebook page, right? And he put all kinds of stuff on his page. He's got personal information, stuff about his family. He's got Bible quotes. He's got stuff about the city. Yay, city. This is all the great stuff the city's doing. And hey, here's my son's sports team. I mean, all these things are out there. Well, as usually happens when you're in the public sphere, you invite detractors, right? And so when they were in the grips of the pandemic in 2020, there was a resident, Kevin Lentke, who took to Mr. Freed's Facebook page and became very critical about how the city was handling the pandemic, what the pandemic response was. And the city manager blocked him. Nope, not doing that. You're not invited into my space anymore. And he deleted all the comments that Kevin Linke had put on his Facebook page. And then Kevin Linke said, you can't do that to me because I'm a citizen and you're my city manager. And you put this out there with all this public information on it. You can't do that. So he sued. And the trial court in the Sixth Circuit, because the Sixth Circuit is, you know, very supportive of regulations, which is a good thing for us, held for Mr. Freed, held for the city manager. It went to the Supreme Court over someone getting blocked on a Facebook page. I will tell you, there are these organizations that exist, and they exist for the sole purpose of finding cases like this and pushing them up to the Supreme Court, right? I mean, and like as a lawyer, when you see one of these complaints, you can tell when someone's behind it because of how it's written. And you're like, like here's the name on it, but I know what organization is really behind that. And we watch those cases and eventually they often make it up here. So the Supreme Court said in its unanimous decision that public officials can be held liable for violating the First Amendment when they block critics. They said this is not an unfettered right. Okay, that's what the Supreme Court said. But they can only be held liable for a First Amendment violation when they are using power to speak on behalf of the office they hold. And they're exercising that power, which means if the city of Huron had said to Mr. Freed, did I get the city right? Had said to Mr. Freed, as our city manager, we want you to have a Facebook page and we want you to communicate with our public on that Facebook page. That would have cloaked Mr. Freed with the authority of the city without question acting as a public official every time he was out there on that Facebook page and social media. But that didn't happen here. This was his private page that he just happened to be talking about city business on. And that changed the nature of the court's view. And Justice Barrett, writing on behalf of that unanimous Supreme Court, said, Mr. Freed did not relinquish his First Amendment rights when he became the city manager. He doesn't have to park his First Amendment rights just because he's in the public sphere, right? Instead, the presence of state authority, meaning whether he was speaking as a public official, it has to be real. There has to be some grant of that authority, and it can't be a mirage that someone's perceiving. So very important things to recognize. So what did the court rule? The court said he was using his social media as a person and not in his official capacity as city manager. And because he did that, there's not going to be liability here. And they remanded the case back to the Sixth Circuit, which means they pushed it back down to the court below them for further action consistent with the ruling. Okay, this is the companion case. So this one, this one dealt with an employee. This one deals with board members. The companion case, O'Connor Ratcliffe versus Garnier, however you pronounce it, 2 school district members with public Facebook pages, right? Profiles, I'm sorry. When they were candidates, they made these Facebook pages. They put all this stuff on it. Then they got elected and they kept the pages and then they put more stuff on it. But now they're elected officials. All right. So again, people are critical. Nobody likes elected officials anymore. It's a thing. And so Mr. Garnier, who really didn't like these 2 public officials, made all kinds of comments. They blocked him. They deleted his comments. He sued because why not? Alleged a violation of his First Amendment rights. The trial court, now we're out there in the Ninth Circuit, which is out in California land, right? Where I'm like, that's a different country from a legal perspective. They come up with a lot of different stuff. So the trial court said, yes, this is a First Amendment violation and it held for the parents. They said, you can't block these parents just because they're saying things you don't like. You can't delete their comments. The Ninth Circuit said, yes, and doubled down on it and said, you can't block these parents. You're a public official. What are you doing? Supreme Court said, not so fast. Not so fast. We just decided this case, the Lenke versus Reed case. That's our standard. Did they act with authority granted to them as school board members? And if so, then there might be a First Amendment violation, but if not, no violation. And they remanded the case down for that standard to be applied. So that's where we are right now. So if you, as representatives of a DD board and employees of a DD board, have authority specifically granted to you by the board to go out there onto social media and say stuff, be wary. Don't be blocking people. Don't be deleting comments, you know, because when you go out there into the public sphere and you invite speech back, you're stuck with it. Okay. But if you're doing it as an individual and you don't have any authority, chances are you do have the ability to block and delete comments and things. And those are the lessons learned here. Lessons learned. There's a distinction between your public and your private life. And we look at the authority that you have. Okay. There's only going to be a First Amendment violation when you, as a public official, are simultaneously restricting access to your personal social media accounts and acting as a public official. Okay, so my best advice is keep your private life private and your public life public. Don't run all of your interest out of one account, right? I mean, that's the best thing you can do. Another case to watch, just to be sure that you've got this on your radar, because I have it on my radar. It is fascinating. And this is coming to us out of Missouri. Murphy versus Missouri. This is the government alleged intervention with social media case. This is the case where we were talking about the COVID-19 measures and the efficacies of the different things that were out there, and the allegation that our government went to these social media platforms and said, please don't do this. Please don't let people post that. Please don't do this. And then the allegation that stuff got deep sixed, right? That there was information that never bubbled up to the surface on these social media platforms because allegedly the government had requested that it not be permitted to. And so the question that the Supreme Court heard argument about, again, the United States Supreme Court, you know, staunch defenders of the First Amendment. So this is going to be interesting. March 18th, 2024, 3 days after they released those other two opinions, they heard these arguments. And the question that they're going to answer is, when the federal government allegedly approaches social media platforms and asks them to do something, are they converting those social media platforms into a public entity subject to constitutional violations? Fascinating, right? Because you think about that, like, what if you, as a public entity, went to a private individual and made a request of them? And they said, okay, does that then convert them into a public entity? I mean, that's the slippery slope of these kinds of arguments. So we'll wait and see what happens. Okay, in the meantime, just understand certain things can be blocked, but mostly everything else can't. And that's on the slides just in case you need it. Oh, my friendly reminder, if you do have a public organizational Facebook page or social media account, make sure you're archiving it. Okay, because even if you delete it, it is subject to your public records retention policy. Just my friendly lawyerly reminder. Okay, other public communications. First, I should stop, check the chat, as if I could operate this technology, which I can, but I don't see anything. Any other questions before we move on? I have just a couple more points to hit, and then I know Becky's got really important stuff to share with you. Yes.
Okay, so if you don't allow commenting on your posts, but with social media and with your website, you would have a contact us form, or you have Messenger. So that's a private form of contacting, which is considered public record. Are you allowed to delete that?
Well,
Because it's public, but not viewable by all.
so it's like two different things at play here, right? The first is if you delete or block, that's what creates the First Amendment potential First Amendment violation. Okay. Public record, though, if you have, say, contact us and people then contact you, that's just creating a public record. And then that you have to retain under your public records retention schedule. So email, contact us forms, responses, all public records. Okay, it's not just the electronic nature of the record that's at play here, it's the substance of it and whether you're maintaining it, right? Because if you're maintaining it and it documents the functions of your organization, we're in public record land. So just be aware, your email is a public record. Also, be aware that series and exchanges of emails can be an Open Meetings Act violation. So this is an Ohio Supreme Court case, White versus King. Just want to make sure you have that on your radars so that, and they call it round robining. Very bad. Don't do it. Like, what do you think? I don't know, but you're only responding to like one board member. But then if you take all of those and you combine them and you can like reach a decision, that's a violation of your Open Meetings Act. Okay. Here's the other case that gets everybody up in arms. Sinclair Media versus City of Cincinnati, and the Cincinnati Enquirer versus the City of Cincinnati. And it's about where things are stored. So text messages, personal email accounts, voicemails, even personal voicemails, or I'm sorry, voicemails kept on a personal cell phone. It doesn't matter where they're stored. If they deal with the business of your DD board, they are a public record. And so this is my plea. Don't use your personal cell phones for texting about business things. You know, don't use your personal emails for texting about those things. I mean, it's much better to have a DD board provided cell phone or to use only your official business email, because my least favorite thing to do, because I represent a lot of entities, is to get a public records request and then to have to go to a board member or an employer say, I need your phone. And they're like, why? This is my phone. And I'm like, but you're conducting business on your phone, so I need your phone. And you don't want, you know, anybody going through the things on your phone, right? Ew. You don't want that to happen. So work phone is work phone, private phone is private. All right. Again, it's about the content of the message. If it documents the DD board's business, it's got the potential to be in public records land. Just be aware of it. And remember, there are still exceptions to production, meaning even if it is a public record, you're going to be combing it to make sure there's no student information in it, there's no private information, there's no medical information, and that gets all redacted out. But we still have to do the search, which makes everybody uncomfortable. Nobody wants to have to do that. So we try to prevent it by not engaging in that in the first place. Okay, board communications, again, adopt a policy about social media. Designate who your social media person is going to be. That's the easiest way to avoid the argument that there's been conflation of roles. Okay, so adopt a policy. Say what you're going to do in your policy and talk right there in your policy about what you're going to prohibit on communications that come back to you, obscene things, defamatory things, outright lies, criminal conduct. Because then you're not scrambling to try to put it in after the fact, you're dealing with it on the front end. And you can say to everybody in the world, these are our reasonable time, place, and manner restrictions. This is not us reacting to the content. We've had this policy in place for 72,000 years, and here it is, right? I'm being facetious, obviously, but I am pretty old. So, student communications, another thing to remain mindful of is you have a lot of communications that are coming to you through the people that you serve. And those communications are also protected, particularly if you're working with school districts, because they're subject to FERPA, you are subject to FERPA, everybody's subject to FERPA. We just want to be very aware that we understand what the limitations are there, that that information is confidential and protected, and that we want to have an acceptable use policy in place so that everybody knows what the rules of the game are about when you're using our email, when you're using our internet, when you're putting things out there into the atmosphere, the internet atmosphere, and what our expectations are going to be, so that again, we're not accused of reacting to the content, but instead we are enforcing our reasonable time, place, and manner restrictions. Same thing with student email. Here's just a few notes about FERPA. I am running late like I always do. More FERPA stuff. Again, our slides are available with the conference materials. And then just a checklist here. Nuts and bolts of good record keeping. Make sure that you're keeping your documents well organized, storing them appropriately electronically, documenting when you should be documenting appropriately. Keep things all in one place. Try not to keep multiple files, right? I mean, I spent a lot of time arguing with opposing counsel about the real file versus the side file. So, have a policy on what are our files and what are we going to keep in those files. Understand that, some things are legally required, and that if you have attorney-client communications, they should not be stored in regular files, because we don't want any inadvertent disclosure, right? We don't want any inadvertent waiver of the privilege. Be thinking too about medical information, obviously in a side file. Who should have access to the records, particularly when it involves schools and students? What is your business purpose, so that we know when something is a public record, and then your records retention schedules. And this is just one more final checklist, things to be thinking about and to have in front of mind. Helpful topics of conversation the next time you're looking for something to talk about. Like, just the risks of emails and text messages, being aware that even if it's on your private phone, it's subject to disclosure. Understand that there are repercussions, especially in audits, for having sloppy files and not dealing with public records correctly. Understand the high level of confidentiality that applies to everything you do and the services that you provide. We want to make sure we've got FERPA compliance, understand who can access records. And this is a big thing again lately, who gets to see it. It's not open to everybody. It shouldn't be laying out on tables, right? It shouldn't be something that's on an open throughout your organization site. We want there to be limits to access. And then especially as it relates to special ed records. So that's all I had from my legal constitutional analysis, and I'm handing it over to my friend Becky to talk about all the other fun stuff. That is the button.
And I apologize, I'm getting over the crud, I'm not contagious. But we have presented to OACB about ballot communication before. And we thought it might be good to just do a quick PS on where things are now. So we'll buzz through that, and then I want to take a minute and talk about what's happening on the property tax side of things. So the law is actually old. It has been around since before 2000, so it's 25 years old, I think. It's always been there. But what has changed is enforcement. And again, I know some folks are hybrid. You can look at these slides as well. Where we get in trouble is when there's an allegation that you're using public funds to support or oppose a levy. Now, that doesn't mean you can't communicate with your public. That doesn't mean that at all. It doesn't mean you can't have newsletters or Facebook page or whatever. It doesn't mean that at all. What it does mean is you cannot be persuasive, which is very hard for you all. I know some of you in the room, and you are very passionate about what you do. But you're going to have to put a lid on it. And you're going to have to get a committee that's good, high functioning, to do what needs to be done to your county in terms of understanding where you are and where you're going. You can't coerce employees to give to the levy campaign, and you can be involved in promoting the levy as long as you do it on your own time. And of course, the big question is, when are you ever on your own time? Document, document, document. If you go out on a Sunday afternoon to drop literature, that's pretty easy. If you're going to take off during the workday, make sure that is documented somewhere. We have a lot of slides of do's and don'ts, and I'm not going to go through all of that. But if there's anything you remember from this part of the presentation, remember these three words: neutral, verifiable, and factual. Neutral, verifiable, and factual. You can go to Rotary and talk about the population that you serve. You are different. Your constituency is cradle to grave, cradle to grave. And that makes you different. That makes you have different kinds of needs and services that need to be provided to those folks. And you can talk about that. There's nothing in the law or even in the Otter Estates guidance that says you cannot communicate. You can, but let your levy committee do all the heavy lifting. And it probably goes without saying, don't store the levy signs at your office. So again, here are all of these do's and don'ts. Let the levy committee do everything that could be discerned as persuasive. And one of the things that I think is unique to you all is the metamorphosis that DD boards have had during my career. One of the things that I still hear, well, you don't need the levy because you don't have the school anymore. You can refute that, again, in a factual, neutral way. And you can verify that, yes, you serve a cradle to grave constituency. These are the numbers of people that you serve. And the service still has to be provided, even if your role in doing so has changed. And sad to say, even the county commissioners don't always get this. Oh, bless you. You can tell she's a mother. Oh, she gave that. Look at this. I'm really hot about this right now. We had a school district. Anybody here from Geauga County? Anybody? You know. West Geauga schools got reamed by the County Budget Commission because their balance was too high. Now, West G is a lovely area. You'd agree with me. Not necessarily high wealth. And their election history is sketchy. They had just failed a renewal improvement levy. So it's not like, well, you always pass everything. So if we don't put your levy on for collection next year, you could just go get another one. This is a real problem because it's coming at the same time we have the Joint Committee on Property Tax Review looking at everything under the sun because they're knee-jerk reacting to the sexennial reappraisal results. And I won't name them, a DD board that's supposed to meet tonight. They were supposed to call me yesterday to say how their meeting with the county went. They were trying to decide whether they were going to do another 10-year levy or do a continuing levy. Well, they called me after the meeting and said, well, the commissioners want us to reduce our millage. You don't run the school anymore. Why do you need the money? So you are in a unique spot, but never fear. There's a lot of law out there that says, particularly in the DD context, that just because you don't run the school anymore, if you are providing funding for the services to be provided, it does not matter as long as the levy is being used for the purpose of providing the services. And for any of you that are looking at levies for November, be sure, and this is in the 6th paragraph of 5705.222A, because Bridget and I put it in there, that you can change the purpose of your levy to the purpose in the statute. So you aren't stuck which that references the school. And that is a unique thing, because generally, if you're having a levy go up for renewal, you can't change purpose. But we got that in there. The other thing we got in there was 5705.322, charmingly buried in some legislation we were working on. But if the Budget Commission wants to cut you, guess what? They have to have a public hearing, and they have to notify you, and they have to publish a notice in the paper. Anybody here from Sandusky? Anybody? Well, their Budget Commission was feeling their oats and tried to do that. And your people, parents and students, packed the room. Needless to say, they beat a hasty retreat, but that is in there, and they have to take into account your 5-year forecast in cutting you. You guys are a little bit like the camel with the hump. You need to live off the hump until the next levy gets done. It's not as if you can just go out tomorrow and go on the ballot. The legislature's really reduced your opportunities to be on the ballot. And so if you hear of this happening, make them stick to the rules, follow statute, let us know when hearing's going to be, and we'll be there. So sorry to be so fired up, but this is a battle that I have some history with. My grandmother was the first, what they called back then, teacher of the educable mentally retarded in the Canton City schools. And so this is something I carry. Thank you. You're wand. Thank you.
All right, thanks, everybody. This was a great information packed session. We want to thank Beverly and Becky for being here today. And again, these slides are available in Member Connect. You can download those for all the good information.